co-ownership of land, rights, remedies, and global insights. Imagine owning a property, but not alone. Someone else has equal rights to it, or maybe more. How do you share? Who decides? What happens when there is a dispute? Co-ownership occurs when two or more people hold legal or equitable interests in the same land. Each co-owner has rights to possession, use, and sometimes profits, though shares may differ. This is relevant in family homes, investment properties, business real estate, inheritance and estates. Globally, co-ownership is common and disputes arise frequently. Understanding the law helps avoid conflict and ensures fairness. Examples around the world. UK, co-ownership is codified under common law and TOLATA 1996. In Ghana, co-ownership is governed under the Land Title Registration Act 1986 and customary land rules. In Southern Africa, common law distinguishes joint tenants and tenants in common. Trust Property Control Act also applies. In Canada, particularly in Ontario and Alberta, they have specific statutes recognizing joint tenancy and tenancy in common. In the US, this is varied by state. For example, California recognizes joint tenancy with right of survivorship. New York uses both forms. In Australia, real property acts in each state regulate co-ownership. For example, NSW Property Law Act 1969. In Sweden, co-ownership is governed under the Swedish Land Code, Jordabalken 1970. In China, property law recognizes multiple owners, especially in shared housing estates. In Korea, civil code regulates joint ownership and co-ownership of property. Now, what is joint tenancy and tenancy in common? These are basic definitions in land law that one should be comfortable with. Joint tenancy. Here, all co-owners hold property as a single unit, sharing equal rights of possession and the right of survivorship. That is, when one owner dies, their share automatically passes to the surviving co-owners. On the other hand, tenancy in common. Here, co-owners hold distinct shares, which may be equal or unequal. And here, shares can be sold, gifted, or left in a will, and no right of survivorship exists. Locus Classicus case, UK, C. Redraper's Conveyance, 1969, Chancery 486. confirmed the distinction between joint tenancy and tenancy in common. Modern UK example, Stark versus Dowden, 2007, UKHL 17, co-ownership in family homes can be joint tenancy or tenancy in common, depending on parties' intentions and contributions. Global cases, Ghana, Osei versus Mensah, High Court, Accra, 2016. Dispute between siblings over family property, tenancy in common recognized. South Africa, Nsimango versus Nsimango, 2018. Unequal shares inferred for joint purchase of property. Canada, see the case of Carr versus Barono, 2011, LCC 10. Beneficial shares can be inferred from financial contributions. USA, particularly California, Estate of Davis, 2017. Right of survivorship applied. Joint tenancy confirmed. Australia, NSW, Malone versus Skelly, 2019. Property purchased jointly. Court confirmed tenancy in common. Shares. Now, how would your family or business structure ownership? Are all shares equal, or does contribution matter? Four unities of joint tenancy. The four unities of joint tenancy. 1. Unity of possession. Here, each co-owner may occupy the whole property. 2. Unity of interest. Here, identical estates or equal shares. 3. Unity of title. Here, all acquired under the same document. 4. Unity of time. Interests acquired simultaneously, that is at the same time. Locus Classicus, UK, Williams versus Hensman, 1861, 1 J and H 546. This explains severance of joint tenancy if one unity is broken. Modern cases in the UK, Burgess against Ronsley, 1975, CH 429, agreement to deal with one's share can sever joint tenancy. New York, USA, in Real Estate of Smith, 2015, sale of share by one tenant converted joint tenancy into tenancy in common. South Africa, Botha versus Botha, 2014. Severance recognized through mutual agreement. Reflection. Breaking a unity is not just technical, it affects inheritance, it affects control and rights after death. Creation of co-ownership. Co-ownership may be created by one of the following methods. 1. Express agreement, by deed, contract, or written instrument. 2. By the operation of law, which may be by inheritance or joint purchase. 3. It may be implied by trust, especially for family homes. Contributions to purchase price can create equitable interest. See the case in the UK, Stark versus Dowden, 2007, UKHL 17, contributions inferred co-ownership. See also Jones versus Kernott 2011, UKSC 53, shares adjusted over time based on contribution and intentions. Canada, Kerr versus Barano 2011, SCC 10, financial contribution can infer beneficial ownership. Australia, Gumeli versus Gumeli 1999, contribution to family home creates trust-based interests. USA, particularly California, see Marvin and Marvin 1976, non-marital cohabitation can create equal and equitable interests. Sweden, Hogstay Domstolen 2010, joint purchase with unequal contribution, shares inferred. Korea, Supreme Court 2014, contribution to purchase fund create co-ownership. China, Beijing High Court 2018, equity in housing recognized when both parties fund purchase. Reflection. Think about situations where money, not name on title, affects co-ownership or affects ownership. Many disputes arise from ignoring contributions. Severance of joint tenancy. Severance. This converts joint tenancy into tenancy in common and ends right of survivorship. Severance can be done by the following methods. 1. Notice in writing. 2. By mutual agreement. 3. By court order. 4. By disposition of interest. See the cases below. William versus Hensman in the UK 1861 outlined severance methods. See the case of Burgess against Ramsley 1975, agreement to sell shares effects severance. Canada, Tremblay versus Tremblay 2016, one co-owner selling share ended joint tenancy. US, in Texas, in real estate of Johnson 2018, written notice sufficient for severance. Australia, Marlon versus Skelly 2019, severance confirmed by court order. Sweden, Stockholm Court 1915, severance recognized for unequal contribution. Reflection. Severance can affect inheritance. Do you want your co-owner to automatically inherit your share? TOLATA and Trust of Land. The Trust of Land and Appointment of Trustees Act 1996, also known as TOLATA, governs rights and duties of co-owners and trustees in the UK. However, court can order sale or occupation. Trustees manage proceeds or land. UK cases. See Stark and Dowden 2007, which applied TOLATA principle to family home. See the case of Jones and Kernott 2011, in which quantifying beneficial shares under TOLATA stands. International examples. See the case of Kerr against Barano, in which equivalent equitable in principles applied. See also in Australia, Gumeli versus Gumeli, in which trustee obligations to manage jointly owned property upheld. South Africa Trust Property Control Act 57/1988, courts oversee joint property management. In Sweden, co-ownership regulated under jordabalken, courts can order petition. USA, court managed co-ownership trust in multiple states for dispute resolution. Rights and remedies of co-owners. Rights and remedies of co-owners. Rights. Possession. Each co-owner can occupy whole property. Profits from rent, leases, or sale proceeds. Accounting, proportionate share of income or sale proceeds. Remedies. Partition or sale under TOLATA section 14. Court orders for occupation, management, or sale. See the case of Stark versus Dowden, in which contributions and intentions determine equitable shares. See also Jones versus Kernott, in which court adjusts shares based on reality. See also in Canada, Kerr versus Barano, remedies includes constructive trust and equitable accounting. South Africa, Msimango versus Imango, partition granted. See also in Australia, Gumeli versus Gumeli, court orders sale to divide proceeds. Your reflection and my reflection. Co-ownership is as much about relationship as law, and disputes often arise from unspoken expectations. Conclusions. Co-ownership can be complex. Law distinguishes joint tenancy and tenancy in common. The four unities are critical in joint tenancy. Severance changes rights fundamentally. Contributions, financial or otherwise, can infer co-ownership shares under trust. Courts globally apply equitable principles to adjust shares fairly. TOLATA in the UK and equivalent laws provide remedies for occupation, sale, or accounting. Understanding co-ownership prevents disputes, ensures fair outcomes, and protects investments. It is worthy to note that co-ownership is not just a legal concept, it's a lived reality. Whether in London, Accra, Sydney, Seoul, Beijing, people sharing property must navigate rights, contributions, and relationships. The law is your guide, but communication is your first safeguard.